Hello people, it is I once again. We have a nice little video here for you. This is a very quick one, just about the form of legal paperwork, the style of it, how they lay it out for their society, particularly when it involves government entities, and how we'll get onto the important facts around loopholes. The war of words, the definition of words, and the concise meaning of words in legislation like statutes and stuff like that. Which isn't really relevant for the common man, but this is very relevant for the government, because the government obviously are charged with the smooth administration of the public roads, which is what this is all about, but also like public property, you could say, so that the use of enjoyment by all can be had without risk of personal injury. Now I'll surmise this case very briefly. A guy pops out of his house, walks down his driveway or his front path, whatever you call it in America, and you get down to the pavement and you walk, or the sidewalk, sorry, and once you get there you slip on a bit of moss. So this is a case very much about who's liable for cleaning the moss off the sidewalk stroke pavement. So he slipped, he had a personal injury, and he decided to take his claim against the council for not keeping the footpath. That's a better way of putting it. The footpath. I think everyone can understand what that is. Not keeping the footpath in good state of repair. So here we go. Now I want to just look at this because this is kind of like form. So it's got an emblem up here, makes it look all official. The Royal Courts of Justice. Neutral citation number. Now clearly, as soon as you start seeing this kind of stuff, you know in the realms of legal mumbo gumbo. But the only thing we would recognise on here is the fact that this case has been assigned a case number. A citation number, I think, is that for their code books when they stick it in their code books? Yeah, it's got the year, EW, what, High Court, something like that. 3330, blah blah blah. So this could be cited in their blue books or whatever they use in their society. So again, here we got the form is like in the High Court of Justice, Queen's Bench. So the High Court is the government consolidated courts. Okay, so that's how they merged all the miscellaneous courts that are out in our kingdom, in our land of the UK. Sorry for saying UK, but you'll get what I mean. And the High Court is everything squeezed together in one big package. And then you've got the divisions of the High Court being the Queen's Bench division. And then also here in the Birmingham County Court. So it's interesting that it's gone county to... that's two separate things in my opinion. The Queen's Bench division of the High Court is its own thing. But then they're also saying it's now also in the Birmingham County Court. Now County Court would be personal torts. Which can also be heard. I know the Queen's Bench division deal with torts and trespasses, so I don't know if that's how it started off, maybe in the Birmingham Court and it's gone up to the Queen's Bench division, or it started in the High Court Queen's Bench division and then sent down to the local Birmingham County Court. Something of that respect has happened. So before a Mr. Justice, which is an interesting way. Now remember, there's no real judges on planet Earth that you can answer to. The only judge is in the afterlife, which is the Judeo-Christian belief, where when you die, you meet your Maker, and the Maker says, "Have you been good or bad?" and throws you upstairs or downstairs depending on how well you've been. And I also missed this thing here, the Royal Courts of Justice. So that's the actual building itself. So the High Court is not the Royal Courts of Justice. It just so happens that the administration of the High Court is at the Royal Courts of Justice, not in the Royal Courts of Justice. And then you have the parties. So you have the claimant, the defendant. Now this is public information on here, so there are some addresses and stuff. So once you bring a case, it's open to the public review. This is a public gov website. Anyone can look at it. So it is what it is. So Craig Rowlinson and the Dudley Metropolitan Borough Council. And then it comes on to something called an approved judgment. Now I was thinking about that. Who would approve the judgment? Now in a court of law with people would be after a jury trial, whether it be criminal or civil, the jury would render a verdict, and the judge would sign off the I presume the judge witnesses the jury's verdict. So obviously here it's not going in front of a jury, but it's going in front of a judge who's now approved a judgment. It's a different way of doing things. maybe for the administration, the speedy administration of justice. So this is basically, it's been determined one way, and the council have brought it back up to an appeal. So basically, on the morning of blah blah blah, some guy walks out of his footpath. If you want to read it, by all means, freeze and read. He walks out of his footpath and slips over. The judge has initially ruled in his favour under some sort of Highways Act that the government has to comply to. And this raises an important question about local councils under the duty to keep all roads, pavements and footpaths throughout England and Wales free of moss and algae. The existence of such a duty would put serious logistical and budgetary implications for all councils. So they're basically saying, is this really feasible, realistic, reasonable, is always a nice way of these guys saying. So there has that guy, just gives him a little bit of his details. So that's basically it. I just like the form of it at the top and how it's cited. So this is man. Well, I presume a man. I mean, it's Mr. Craig Rowlandson versus the council. So the man being represented in the legal capacity is taking the fiction, the legal entity, to court. So this is the citation in the legislation. So the 3 points is of evidence were presented to the court, and the court obviously has to look at the rule book and say, wait, what's going on here? But this is quite interesting. So on the government's rules on their duties to the public are set out in this act. So it has here section 41 of that particular duty to maintain the highways at public expense. So technically, the way that you would read that is like you have to maintain it at whatever expense it is to the public. Interesting. So it's almost like a license to charge the fees that are necessary to make sure that the maintenance is of the standard that means that this kind of stuff doesn't happen. Yeah, so they're citing that kind of stuff. So they're talking about snow and ice and stuff, but in this case it's a like a moss or algae or lichen growing on the road. And what they're doing, they're going through word. This really is where the battle of the words comes in. You might have heard this about loopholes. It's really important when they're going to examine every single word in the statute, every single word that's in the claim, and if there's any kind of like word that doesn't make sense or sticks out like a sore thumb, like that's not true in this example, this is not true in this case, that needs to be changed, or that means that this case is not accurate, then that's exactly what you're doing here. You're having a war of words, yeah? You're crossing words, as it's been said. Instead of crossing swords, you cross your words. So they're going to go through every single here, so citing all the old cases, this, that, and the other. This is how the legal society's common law, if you like, the English common law. This is how it builds up from case history. So they start eliminating rights based on circumstances, or trying to follow what was done previously to reinforce or disprove certain rights based on certain liability chains or negligence. Going from snow to gravel to this, so they're exploring it, they're really delving down. This is very much what the legal society do, they're competent legal interpreters of such code and duties that they have as custodians of the government, if you like. Concrete, so looking at all the surfaces that people walk on, and here are Thomas versus another council, blah 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 blah. Let's refer to that one, see what that was all about. Now they've got 3 grounds that they're doing in terms of their appeal here. So they've got one ground, statutory construction. Now enjoy that one. That's beyond me to even get involved in that kind of nonsense. And they're talking about the evidence now, so they're probably going to tackle and challenge the evidence, which is an interesting angle. That's a bit more relevant to law, witness statements, evidence, photos, what actually happened. And then the contribution of negligence. So was there any negligence on behalf of the council? Which is an interesting way of looking at it. So here they've actually so the judge has already ruled against the council, but this is on appeal, so that now they're looking over it again, and what they've actually decided to do, then they decide to look at the judge's decision, and they've actually decided to rule against a judge. So the original court, is it what they call nisi prius, I think? So the original court of hearing, the first hearing, the first point of jurisdiction, if you like, the judge erred. So they're actually saying the judge has made an error in holding that the council had a duty under some highway act to prevent and remove the moss on the surface of the highway. So again, now they've changed it to highway. Well, was it on a road? Was it on a highway? Was it on a footpath? Was it on a pavement? Was it on a sidewalk? All these different words, they don't mean the same. They might sound similar. They might be synonyms in some respects, but they have their own specific meanings. And these are how you kind of get the loophole angles in deciding, hang on a minute, that didn't quite apply in this case because it wasn't a highway. We're on a footpath, and God knows how they define highway. There might be the road and footpath might be a highway, for example. Who knows? So yeah, there's plainly no such duty, and therefore we're allowing the appeal. So he said he slipped on moss and algae, and they're saying actually there's only moss, there was no algae. So you know they're going to use what you claim will be used against you if it's not exactly right even. The judge didn't make it on moss and algae. So there we are. So let's say a bit of statute legislation says moss and algae, but there's only moss. Then you've got a conflict there in terms and definitions. So therefore there's another discrepancy here as well. See, these are the little. This is how you attack it. You attack the legislation, and you look at what's been said by the other party, whether you're defending or prosecuting. You have to really look at the words that's being used. And this is why you have to be so tight with your wording, not waffle on. Keep it short and concise, to the point, without any opportunity to start ripping your claim or their claim apart, unless that's something you want to do. That's pretty much it. But I just thought it's a really interesting kind of way, because here it shows that the appeal courts are showing that the judge that made the original ruling is actually in error, has made a mistake. The judge has made a mistake, and they'll obviously take that up with him back office, if you like. You know, not in open court. They'll raise their findings to him. But you know, if the person didn't appeal this, if the council didn't appeal it and put a case in front of the appeal court in relation to potential errors in the initial hearing, then this would have stood as true. And the young man, whoever this guy is, Craig, probably would have got a compensation payout. But who knows what happened after this on appeal. But I just thought it was interesting to see the courts ruling against their own judge with a good legal argument, presumably. I mean, I don't know if it's good or bad. I'm not legally qualified, but I can certainly read English and try, in some respects, to interpret legal. But I'm more interested in form and strategy here, in terms of loopholes, attacking the words, and getting a good outcome.